I'm Tristan, and this is Thinking About Politics. So today, we're thinking about something called Rule 11 sanctions, and why a federal judge up in Michigan spent 110 pages explaining how Trump advisors L. Lynn Wood, Sidney, Powell, and their associates brought a lawsuit so bad, the judge literally ordered them to undergo additional education. As fans of this channel will know, Donald Trump and his associates have been forwarding election lies, claiming that somehow the 2020 presidential election was compromised. They have been able to offer zero factual evidence. After the November election in 2020, L. Lynn Wood, Sidney Powell, and others associated with Trump launched dozens of lawsuits across the country, all of which were dismissed, none of which had any merit whatsoever. So again, if you believe in your heart that Donald Trump is actually the president and there was significant election fraud, this video is not for you. But if you have any questions about what happened in 2020, if you want to know the actual facts of what judges and other folks who have looked at this closely make of it, well, go ahead. Why don't you give us a like and a share and a subscribe? You will not be disappointed with our content. So the day before Thanksgiving 2020, about 20 or so days after Donald Trump had lost the general election, attorneys in this case filed a lawsuit. Relying on dozens of affidavits that were collected, these attorneys and the plaintiffs argued that significant vote fraud had undermined the results in the Michigan election. In fact, Donald Trump had won there and probably elsewhere as well. So eventually the defendants in this case filed a motion for sanctions, which is essentially asking the court to punish the attorney for the other side for doing something wrong. So why on earth would we sanction an attorney? Under what circumstances is that appropriate? Don't we want attorneys to represent their side diligently? So friends of the channel will remember that once upon a time we talked about bringing a lawsuit and filing a valid claim, and we talked about a good claim being an example of tack in the pie. You go and get one of those pre-wrapped fruit pies from a store, you bite into it, and there's a thumbtack in there. That's a good claim. You've suffered an injury, it's chewing on a thumbtack. The fruit pie maker has some sort of responsibility to make sure his fruit pies are 100% tack-free. 99.9% tack-free just doesn't cut it. And if you win against the pie maker, well, your harm is probably going to be remedied. You can get a little cash for your medical bills and then maybe something on top for some pain and suffering. Simple enough, right? So let's think about how this plays out in practice. What prevents somebody from lying to the court? Just kind of saying, hey, I got a tack in the pie, without actually getting one. Well, there's things like perjury, where somebody's lying to the court, but you got to be able to catch them in the lie. There's things like discovery, where you give the other side in a lawsuit a chance to get some evidence to try to disprove what you're saying. But there are also rules for attorneys. Ultimately, if you want to prevent people from lying in court, you got to co-opt the attorneys. Every attorney is what you call an officer of the court. They take an oath promising to uphold the truth and generally not to lie. At least not to lie to the court. Defending a claim or prosecuting a claim is one thing, but forwarding an out-and-out lie, not just a fact that you get wrong, but a lie, that's no good. So attorneys have some sort of responsibility to look into the claims, at least a little bit, and to make sure that they're plausible. So for tack in the pie, what would that attorney do? Well, you might ask for the medical bills for the guy who chewed up the tack. You might ask for hospital records. Another thing you might do is you might write a letter to the attorneys of Mr. Fruit Pie and explain what has happened and see if they're amenable to negotiating some sort of settlement. These are things you do that sort of investigate whether or not the claims of the person talking to you are well-founded or well-grounded in truth. Even if it turns out that you're wrong later, was there at least some reason to think you were right at the time? Or were you acting maliciously? When attorneys start doing that sort of thing, judges get mad. It wastes the court's time, the taxpayer money. So when Sammy Scam goes off to Calvin counsel saying, hey, I chewed up a thumbtack in one of Mr. Fruit Pie's, counsel should probably do a little bit of research. And if Sammy tells the attorney, hey, I'm secretly just trying to extort Mr. Fruit Pie, the attorney can't bring that case. Counsel's not supposed to help defraud the court. And it should go without saying that attorneys aren't allowed to cook up scams and use their position as attorneys to get one over. So the federal rules of civil procedure govern how you bring a civil lawsuit. Rule 11 deals with sanctions on attorneys. Section B of Rule 11 says that by presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, An attorney certifies to the best of the person's knowledge, information, and belief formed after a reasonable inquiry under the circumstances. 1. It is not being presented for an improper cause or purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by the existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law, and the factual conditions have evidentiary support, or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So an attorney has to perform some sort of reasonable inquiry to make sure that the claim is not one that's just meant to harass or extend the cost of litigation, that the arguments being made have some legal support, and that the facts being alleged have some factual support, that it's not made up. So you have Rule 11 around for when an attorney starts bringing those frivolous, baseless lawsuits meant to harass, lawsuits without a legal foundation, lawsuits without a factual foundation. That's what the Trump attorneys got hit with. I mean, how do you explain that? But the central purpose of Rule 11 is to deter baseless filings. So when you have these attorneys like Lynn Wood and Sidney Powell, who are licensed in other jurisdictions, you also need a local attorney from the state to allow you to bring the case. So we have local attorneys and we have out-of-state attorneys. So the first line of defense from the out-of-state attorneys is this: nobody signed. You know, our names were like typewritten on the documents, but nobody put a pen to paper. Therefore, we can't be liable. Only the local attorneys could be liable under Rule 11. Yet the local attorneys say that, well, no. We just signed and submitted these. We did not prepare the documents. The out-of-state attorneys prepared the documents. So both sides are pointing at each other. And the court says, that's ridiculous. You guys had your names on these papers. You obviously knew they were being filed and you didn't object. Nice try. By agreeing to put your names on this piece of paper, you get to be held accountable. But oh wait, said Lynn Wood. During this case, the court specifically asked Wood if he gave permission to have his name included on the briefs. And this is Wood's actual answer. I do not specifically recall being asked about the Michigan complaint, but I had generally indicated to Sidney Powell that if she needed a quote-unquote trial lawyer, that I would certainly be willing and available to help her. In this case, obviously my name was included. My experience or my skills apparently were never needed, so I didn't have any involvement with it. Would I have objected to be included by name? I don't believe so. So the court asked Wood if he gave Powell permission to include his names on filings, to which he responded, I didn't object to it, but I didn't know. I actually did not know at the time that my name was going to be included. But I certainly told Miss Powell in discussions that I would help her if she needed me in any of these cases. And in this particular matter, apparently, I was never needed, so I didn't have anything to do with it. Wood even tried to claim that he didn't even know he was in the case until he read about it in a newspaper. So yeah, Wood is not credible. In fact, the judge even says Wood is not credible. So there's two other nobody attorneys who are involved in this, and they deserve a shout out too. Emily Newman tried to wiggle her way out of this by trying to say, well, I only spent 5 hours on this at home. Judge cuts her to pieces. You're an attorney, girl. You put your name on the sheet. And God, what the heck does that from home thing mean? Everybody's working from home. And let's talk about Gregory Roll. Gregory Roll was given the complaint on the day it was going to be filed at about 6:30 at night. By around 11:30 at night, he had finished it and submitted it. He made no additions, he made no deletions, and the complaint was 830 pages long. Roll says it took him well over an hour to review it. Yeah, that sort of careless, sloppy work is exactly why we have things like Rule 11, my friend. The court agrees with the statement of one of the defendants by saying that the suit is driven by partisan political posturing, entirely disconnected from the law. It is the dangerous product of an online feedback loop, with these attorneys citing legal precedent derived not from a serious analysis of case law, but from the rantings of conspiracy theorists sharing amateur analysis and legal fantasy in their social media echo chambers. It is not lost upon the court that the same claims and requested relief that the plaintiff's attorneys presented here were deposed of for many of the same reasons in Michigan courts and by judges in other battleground jurisdictions where the plaintiff's counsel sought to overturn the election results. the fact that no federal district court considering the issue at bar has found them worthy of moving forward supports the conclusion that the plaintiff's claims are frivolous. Judge ain't having it. Plaintiffs allege that certain acts or events constitute violations of the Michigan Election Code when, in fact, plaintiffs' counsel failed to make any inquiry into whether such acts or events were, in fact, lawful. Plaintiffs' counsel presented affidavits that were based on conjecture, speculation, and guesswork. And then the court quotes from the affidavit of Matt Siantar, which is a masterclass on making conjectural leaps and bounds. So you guys ready? The afternoon following the election, I was taking my normal dog walk mid-afternoon. I witnessed a dark van pull into a small post office located in downtown Plymouth, Michigan. I witnessed a young couple pull into the parking lot and proceed to exit the van and open up the back hatch to proceed to take out 2 to 4 very large, clear plastic bags out and walk them over to a running USPS vehicle that appeared as if it was waiting for them. There was no interaction between the couple and any USPS employee, which I felt was very odd. They did not walk inside the post office like a normal customer to drop off mail. It was as if the postal worker was told to meet and stand by until these large bags arrived. The bags were clear plastic with markings in black on the bag, and inside these clear bags was another plastic bag that was not clear. It couldn't see what was inside. There were what looked like a black security tie on the top of each bag, as if it were tamper-evident type of device to secure the bag. By the time I realized I should take pictures of the bags, once I noticed this looking odd, they had taken off. Another oddity was that the appearance of the couple after the drop. They were smiling and laughing at one another. A document containing lengthy musings of one dog walker after encountering a smiling, laughing couple delivering bags of unidentified items in no way serves as evidence that the state laws were violated or that fraud occurred. Here's another one from Melissa Carone. There was 2 vans that pulled into the garage of the counting room, one on day shift and one on night shift. These vans were apparently bringing food into the building. I never saw any food coming out of these vans. Coincidentally, it was announced on the news that Michigan had discovered over 100,000 more ballots, not even 2 hours after the van left. These plaintiffs in their complaint called this an illegal vote dump. So this lawsuit was bad. The evidence was flimsy. Nobody looking at this can come away with anything else but like, wow, this doesn't make any sense. I'm sorry. Just prove me wrong. Read this stuff yourself. It's bonkers. So the court ordered these folks to go to school to take some classes in election law and pleading standards. They're also moving to disbar them in every state where they have a license to practice law. And yeah, these folks should lose their licenses immediately. Not only that, but they have to pay the attorney's bills for the defendants they tried to sue, which is great punishment. So we are stuck here again, asking ourselves, why is 30% of the Republican electorate taken by these claims of fraud? And I think the numbers are reducing. I think getting the truth out there is having a positive benefit. But people are still out there pushing these claims. And you have to separate folks who have been genuinely lied to, folks who are genuinely lying to themselves, than folks who are genuinely lying to others for their own personal benefit. And I can understand those first 2 groups. Those seem like very human things. For that third group, for folks who are pushing this knowingly, you gotta ask, hey, what do they get out of it? But these fraud claims have to stop. And if there was fraud in an election, I want to know about it. If there's any possibility, one scintilla of evidence that there was in fact fraud, I want to research that. I want to find out about it. And what shocks me, what continues to shock me about these claims of fraud is how thoroughly debunked and objectively incorrect they are. If you want to live in a free country, it's not easy. It's hard. It requires a lot out of you. You can't just sit back and not pay attention to politics and watch TV and get your political opinions from memes. You can't do that. You're a citizen in a free society. You have a responsibility to look at this stuff seriously and to take it seriously. Anyway, that's it for me. You've been great. Hope to see you again. But until next time,
I ain't got time
keep
to kiss
thinking.
you now. I'm busy with this mule.